guys, and welcome back to the ASIC podcast. So today we're going to be delving into all things insolvency as usual, and we're going to be looking at the Waterwheel case and one of the key appeal decisions by one of the directors, Elliott, versus ASIC. Now, Emma, do you think you could tell us a bit about the case?
Hi everyone, so today we are going to talk about the Elliott against ASIC case. So this case was heard by the Court of Appeal of the Supreme Court of Victoria in 2004, and specifically by the Chief Justice Warren and Charles and O'Brien justices. So this judgment was handed down after an appeal that was brought following a decision by the Supreme Court of Victoria. The case is about Mr. Elliott, who was a non-executive director of Waterwheel Holding, a group of companies involved in a rice and wheat milling business. So in the month leading up to September 1999, auditors reported Waterwheel's escalating trading losses. Creditors were not paid, and some directors resigned after questioning Waterwheel's solvency. As of 14th of September 1999, Waterwheel was insolvent, and Mr. Elliott allowed Waterwheels to continue to operate, but did not prevent the company from incurring some debts when there were reasonable grounds to suspect insolvency. So Waterwheel was placed in voluntary administration in February 2000. So after that, ASIC brought a civil action for breach of the insolvent trading provision of the Corporation Act against the director of Waterwheels, including Mr. Elliott. And Mr. Elliott was found guilty of breaching Section 588J by Justice Mendy of the Supreme Court of Victoria at first instance, and he has appealed this decision.
Oh, okay. So then what happened when it went on appeal to the court?
So prior to the second trial, Mr. Elliott accepted Justice Mendy's conclusion that Waterwheel was insolvent as early as 14th of September 1999, and that he was aware of reasonable grounds to suspect insolvency at that time. So the Court of Appeal therefore did not have to deal with these considerations. Instead, the appeal centered on the interpretation of Section 588J of the Corporation Act of 2001, and whether Mr. Elliott, as an individual non-executive director, had a duty to take action that would have been effective in preventing Waterwheels from incurring the debt, and whether he failed to take that action. The court was also asked to consider each individual debt incurred to determine whether there had been a breach of the law in respect of each debt. The court was also asked to determine whether the fact that the company had entered into deeds of arrangement mean that an order of compensation could not or should not be made against Mr. Elliott. So the Court of Appeal agreed with Justice Mendy's decision and dismissed Elliott's appeal. The court held that a director, including a non-executive director, breaches the insolvent trading provision by not preventing or failing to prevent a company from incurring a debt. So if the debt is incurred when there are reasonable grounds for suspecting insolvency, then the director will be taken to have failed. In fact, the Court of Appeal has confirmed that the businessman John Elliott, as a non-executive director, failed to prevent the Waterwheel companies from trading while they were insolvent. As to the pecuniary penalty order of $50,000 against Mr. Elliott, the Court of Appeal agreed with the trial judges. It also confirmed the trial judge's compensation order of $1.5 million against Mr. Elliott. The court explained that the fact that the company entered into deeds of company arrangement did not mean that the creditors had not suffered. So the court confirmed that, I quote, "So far as the dividends payable under the deeds of company arrangement do not fully repay to the creditor the amount of the debt, the creditor has still suffered loss and damage because of the company's insolvency, even if the debt is extinguished and the company has the benefits of a release under a deed of arrangement." So finally, Mr. Elliott was found guilty of breaching Section 588G of the Corporation Act of 2001. The Court of Appeal confirmed the prohibitions against Mr. Elliott, which Judges Mendy made, disqualifying him from operating a business for 4 years. In addition, Mr. Elliott was also ordered to pay compensation of approximately $1.5 million and $15,000 monetary penalty to ASIC. So now, Connie, do you think you could tell us a bit about why this case is actually relevant to insolvency law?
Of course. So this case is really interesting in the sense that it had a wide-ranging impact on the area of insolvency litigation and the onus put upon non-executive directors, as well as a further implication regarding ASIC as a regulatory body to increase litigation in this area of law. The appeal decision exemplified the need of non-executive directors to actively inquire and make themselves aware of current financial position of the company, not just to rely on the advice of others in the company. Justice Mandy in the case stated that a non-executive director is expected to take steps to put himself in a position to monitor the company and to form an independent judgment and to take a diligent and intelligent interest in the information of the company. This notion was reinforced in the Court of Appeal by Chief Justice Warren and Justices Charles and O'Brien, stating that a director, including a non-executive director, breaches the insolvent trading provisions by not preventing or failing to prevent a company from incurring a debt. The precedent set in this case requires that not only directors, but non-executive directors need to take all reasonable steps to ensure the company is solvent and to prevent the company from insolvent trading. In practice, and this is what was exemplified through the case, is that this would include sufficient questioning of the company's financial position, seeking external advice from an expert where appropriate, and this serious consideration as to the appointment of an administrator. If the director does not manage to meet this requirement or persuade the majority of the company's directors to stop them from trading, then, as what we found out through the Elliott case, is that this director should remove himself from the company and resign. The case also gave insight as to what facts would amount to grounds of suspecting insolvent trading, such as the unexplained resignations of co-directors, which actually happened in the case, as well as the withdrawal or intervention of the company's primary banker, which was ANZ in Elliott's case, and they appointed an investigative accountant and placed all facility arrangements on demand. As mentioned earlier, the interesting wider implication of ASIC and Elliott is the position of ASIC and its newfound determination to set up its litigation in the area of insolvency law. ASIC kind of really used this case to exemplify the magnitude of onus on all directors, including non-executive directors, to actively prevent insolvent trading. Prior to the Elliott and Waterville case, it could be said that ASIC, to an extent, was not excessively aggressive in bringing actions against directors of failed companies, that this Elliott case presented an opportunity to pursue a high-profile target, and they kind of wanted to make a statement of intent on insolvent trading. In a press release that has now been withdrawn, David Knott, the chairman of ASIC at the time, stated that the punishment was for failing to act with reasonable care and diligence, and the scale of punishment reflected an increase in punishments being levied for white-collar offences. The true significance of this case is in the reality of a harsher onus imposed by ASIC on non-executive directors to prevent insolvent trading. Through using Elliott as an example and its subsequent punishments, ASIC has made a clear warning for non-executive directors that they will not be excused nor protected for not appropriately informing themselves of the company's true financial position and to prevent insolvent trading.
Are there similar cases?
We actually have two comparative cases in this sense. Is the Statewide Tobacco Services and Morley case and the Deputy Commissioner of Taxation versus Clark. The legal motif running throughout these three respective cases is this notion of the burden of directors, especially non-executive directors, to take a diligent and intelligent interest in the information, financial information of the company. The Deputy Commissioner of Taxation and Clark case deals with a family company in which husband and wife are the directors, Mr. and Mrs. Clark. Mrs. Clark accepted the appointment of being a director only for the purpose of meeting the requirement by law of having two directors of the company. So she really didn't participate in the management of the company and solely relied on Mr. Clark. The company then later incurred a debt while insolvent, and Mr. Clark was found liable for insolvent trading. The issue brought before the court here was whether Ms. Clark could rely on the defence of Section 588H4 to avoid liability for insolvent trading on the basis that she left the company's affairs to her husband. That could the delegation by a director for the entire management of the company constitute some other good reason, which is in Section 588H.4. The court held that Mrs. Clark was not able to avoid liability and rely on this defence, or it did not constitute some other good reason. Chief Justice Spiegelman stated that the assumption under Section 588G and Section 588H is that a director participates in the management of the company and that the total failure to participate for whatever reason does not constitute a good reason, and that this expectation of directors to participate is a basal structure of the Australian corporation legislation. Directors need to actively participate. The statewide tobacco services in Morley similarly deals with this family company run primarily by a husband, Mr. Morley, and after Mr. Morley unfortunately passed away, Mrs. Morley and her daughter, they remained as shareholders and directors, but the management of the company fell solely upon Mrs. and Mrs. Morley's son and another director. But unlike Mrs. Clark, Mrs. Morley did receive an income and did sign certain documents as her capacity as director, but made no effort to monitor how the company was being managed by her son. The son, in his capacity as director, was found to incur debts to Statewide Tobacco Services, who is a creditor, while insolvent. So, Statewide Tobacco Services then sued Mrs. Morley for breaching her statutory obligation to not allow the company to trade while insolvent. The issue contended before the court here was whether Mrs. Morley could similarly use her reliance on her son to properly manage the company as a defence to insolvent trading. However, the Victorian Supreme Court passed down that Mrs. Morley couldn't rely on her lack of participation in the management and that it couldn't excuse her statutory obligation. Justice Ormiston stated that a director is obliged to inform himself or herself as to the financial affairs of the company. The Morley case cemented again that this responsibility of directors, even non-executive directors, to constantly monitor the financial performance of the company, and that there is no valid defence against insolvent trading if they don't actively pursue and ensure this. The similarity of Elliott and Clark is the importance and obligation of non-executive directors to actively and appropriately inform themselves of the company's true financial position. Although the facts are inherently different between Clark and Elliott, the specific legal issues also do differ. The court specifically looks at Section 588H for some other good reason in Clark, whereas in Elliott, it was more under Section 588G and surrounding personal liability for companies' debts. And the crux of Elliott's appeal was that a breach of Section 588G could only be established where the directors sued under that section were aware of the company incurring that specific debt and had a duty to prevent incurring that specific debt. Notwithstanding, Clark similarly highlighted this importance of intelligently and diligently acquainting oneself as a director to the financial management and position of the company. The facts of Morley and the role of Mrs. Morley played in the company are also very similar, as we've said, in the sense of Mrs. Clark being a sleeping director, which is a key term and which is a term regularly used, kind of colloquially, that extends to non-executive directors. Further, this implication considered in both Clark and Elliott, demonstrating the necessary commitment expected of directors, especially non-executive directors, when managing the company. It illustrates that being absent or relying on other directors without a valid cause or good reason is incongruent to the positive duty imposed on directors to take an active part in the affairs of the company. Both Morley and Clark extend the importance of the role and duty levied on non-executive directors, as we have mentioned quite a few times, both similarly exploring the positive obligation on all directors to stop the company trading while insolvent. And where directors can't prevent insolvent trading, as we saw through Elliott, there is an obligation to resign as director immediately.
Thank you for that, Connie. So I think that brings us to the end of our podcast today.
Thanks for listening, guys. You can find us where you get your daily dose of podcasts, either Spotify or Apple. Bye.
Bye, everyone.